At Hughes & Meisner, we educate your beneficiaries and fiduciaries. This education prevents the first major problem of poor estate planning. The first problem is fiduciary and beneficiary ignorance. We explain in a moment what a fiduciary and beneficiary is. But first, we want to invoke two images here: dusty documents and heavy burdens. Deep in dusty estate planning documents is found the name of the most important person in your estate planning. That person is your fiduciary, often called your executor, trustee, or agent. The person you choose to manage your affairs and assets when you cannot manage them yourself. For instance, after careful thought, you may choose an adult child to act as your future fiduciary. However, in the future, at your incapacity or death, the burdens on your fiduciary will, one by one, weigh heavy. When your fiduciary begins managing your affairs, they still have their own lives to live and their own stressful responsibilities to manage. Further, your intelligent fiduciary may lack the experience required to deal with a dozen property, tax, and other legal issues that cannot be ignored in winding down or carrying on the affairs of your lifetime. In addition, your fiduciary must oversee all your affairs while grieving your mental absence or death. And your beneficiaries, your children or others receiving an inheritance, are simultaneously curious and then often demanding. Finally, during all this stress, your fiduciary and beneficiaries are blowing the dust off your legal documents for the first time. Documents they have never seen and that by law they must now translate, implement, and follow. No wonder good fiduciaries are often stressed out and subsequently make mistakes, sometimes very serious and costly mistakes. And no wonder beneficiaries are often impatient and demanding. And then, unfortunately, there are sometimes a few fiduciaries who possess a certain pride as they insist they know best how to administer your affairs without the need to examine those dusty documents. Or there are beneficiaries who have some sense of inflated knowledge and also insist the dusty documents can be ignored. In worst cases, an overconfident fiduciary can become a mini dictator, and overconfident beneficiaries can become hostile. As your family's guide, you can do something now while you are alive to mitigate future fiduciary stress and prevent mistakes. You can invite your fiduciaries and beneficiaries to understand now, before your incapacity or death, how your documents work and how your affairs must be administered. Most importantly, you can educate your fiduciaries and beneficiaries while keeping final distribution plans completely private and emphasizing that you may change those plans at any time. Specifically, we, as Tier 1 attorneys, want to teach your fiduciaries, while you are present, how to be fiduciaries. Further, as Tier 1 attorneys, we want to teach your beneficiaries, while you are present, all the elements that go into administering your estate. This insistence on teaching a client's fiduciaries how to be a fiduciary and teaching beneficiaries how estates are administered is very rare and distinguishes at best 20 to 30 attorneys in Utah as Tier 1 attorneys. You do have a completely different option. You could simply name a professional to act as your fiduciary. For decades, our law firm has acted as professional fiduciaries, administering dozens of clients' trusts with millions of dollars under management. As professional fiduciaries, we ensure beneficiaries are educated in what goes into administering an estate. However, our careful education of your family fiduciaries, as well as your beneficiaries, is often more effective in ensuring your affairs are appropriately managed than retaining a professional. In brief, the first essential quality of Tier 1 estate planning attorneys is that we insist, for your benefit and that of your family, on educating your family.